about this. I have a question that is tormenting my mind all this time, and Professor Conway wants afterwards to follow. But maybe once I'm speaking now to answer the question. The question, Professor Stevens, is about jus ad bellum. You said that the temporary maybe jamming of the satellite will not constitute an attack under 2.4. What about, though, the fact that on jus ad bellum on the ground, on conventional warfare, according to Dienstein at least, even an isolated incident, if it is of gravity, it can give rise to the right of self-defense, meaning Article 51 of the UN Charter. Why don't we apply mutatis mutandis, the same idea, also on space? This is my question. And maybe, Dr. Madikian, we want to hear also the question from Dr. Conway, and then to proceed, it's up to you.
Yes, we can collect. Yes. And just to let you know, we have also one question in the Q&A chat box, but we are collecting all of the questions at the end. And
exactly. Now it's this discussion for the audience, for you to get inspired by us as we speak orally. In the end, we're going to address also your question as the audience.
Please, Gerard.
Yeah, thank you for the presentation. If you don't know much about, I guess you either know something about outer space law, or you don't know very much. And I have to say I don't know very much about it, but it was very clear the way you explained things and identified the issues. I want to ask you about the you mentioned the International Committee of the Red Cross was doing work to develop standards and principles in the area. What's the approach of, I suppose that the states most interested are the states who have space programs and who are active in space. What is their approach to the issue? Do they tend to sort of have their own sort of foreign policy approach to it, or is there any kind of coordination between these states? Are they working together to develop standards, or what's the current state of play amongst major powers?
Thank you very much. Perhaps Professor Mardikan, if I could answer those two questions. Are you okay with me doing that?
Of course. Yes.
So firstly, the first question, Solon, is that I'm not saying the point I'm making is that absolutely Article 2.4 applies into space and Article 51 and all of the normal law. In fact, the Article 3 of the OSC says exactly that. But what I do want to point to is state practice. And what you have seen, one of the things we're doing, and Lisa made mention of the Woomera Manual, one of the things we've been doing is tracking state practice over the last 50 years. And what you're finding is that states, when it comes to satellites, have been engaging in quite elaborate jamming and spoofing activity. And when that has occurred, the reaction of states is to protest. And we have multiple examples of states protesting. The US State Department, NATO nations protesting. But we have not found any instance ever of any state that has said that jamming of their satellites, and I'm putting, let me be clear, I'm putting to one side early warning satellites, nuclear early warning satellites. They're in a category of their own, but normal satellites, normal surveillance, reconnaissance, communication satellites, we have yet to find any instance of any state ever saying that you have now crossed an Article 2.4 line. I can see why you could. I can make an academic argument for why that could occur, but there's been a total reluctance so far for states to make that claim. So, guided by that, I have a level of confidence by saying that jamming is in that grey zone, and it's why I think Russia is doing that rather than destroying satellites, because it is in that grey zone. Was my view. As to Gerard's question, yes, there's been, as I said at the beginning, the United States has in their Law of War manual, they have got some commentary about the application of the law of armed conflict to space, but they're probably at the vanguard of states saying anything about this, at least in their established manuals. and so it raises the question, what elements of the law of armed conflict do apply into space? Because surely it must. Surely it's not a Wild West. If the worst case happens and there's armed conflict, surely the law of armed conflict applies. And you can point to judgments, the Nuclear Weapons Advisory Opinion. You can look at the actual wording of the Geneva Conventions. But the problem with a lot of conventions is they're bound to land or sea, or in some instances, an additional protocol one to air. And so what you've got to do is distill down key universal principles, distinction, proportionality, precautions that apply as a matter of customary international law everywhere, and then make an assessment on how they would apply. And the ICRC is on record with a statement that they made a couple of years ago about how they would apply in order to restrain states, restrict states. And it's a starting point. It's a starting point for discussion. As Lisa said, we've been involved in the Woomera Manual, and I know that Ram will no doubt talk about the McGill Manual, but in the context of the Woomera Manual, we have been engaging with states, and we have asked them their views, and they have volunteered them. They have volunteered with a level of caution because thankfully, there's been no armed conflict in space, and hopefully it will remain that way forever. But in the event that it does happen, we want to make sure that there's law available to restrain activity. And so that discussion, I would say, has just started. And I think we will see in the next decade or so more specificity from states in regards to this issue. And of course, there is the open-ended working group, that UN open-ended working group that is looking at that. And there's a difference of opinion about whether this should even be discussed. I know some states choose